Good evening. Tonight we'll be discussing Chapter 13 of Bates Environmental Law in Australia, which deals with the topic of native wildlife and threatened species. It is a relatively easy night tonight, and if you'd like to follow me in the commentary, please feel free to do so. We start at page 511 at sub-chapter 13.2, dealing with the matter of Commonwealth responsibilities. And two of the main contributors to wildlife vulnerability are habitat destruction and trade, and there's reference there to CITES, the International Agreement or Convention on International Trade in Endangered Species of Wild Fauna and Flora, and that was from 1973. Since 1973, several things have occurred which have built on that. We'll start by commentary from 1976, which is the House of Representatives, the Standing Committee on Environmental and Conservation. And in that instance, there was a report where it was decided that strong controls need to be established on the overseas supply of unique Australian species. The problem is, of course, that that then provided a strong incentive for smuggling. And ultimately, the Standing Committee recommended some relaxation. And those proposals were eventually taken up in the next line of reform, which was in 1999 through EPBCA. Now, at Chapter 13.4, Bates goes on to talk about courts and the way they've interacted in this regard as well, where they have taken generally a strong stance and seen the need to deter offenders. The first case cited is DPP against Robinson from 1992, where the prosecutor argued that a fine was inadequate and custodial sentence should be imposed. The offenders, said the judge, must expect substantial sentences of imprisonment because if wildlife was to be protected, word would spread that jail would be the usual result for importing or exporting protected species without a permit. The court did hold, however, that the offences, whilst serious, were in a sense victimless in terms of human suffering, and no cruelty had been apparent, and the specimens were not rare in Australia. At 13.6, the provisions of EPBCA make it an offence to export or import CITES specimens or regulated native specimens without a permit. All right, so that's the very quick introduction to the Commonwealth regime. If we turn to page 519, there's some commentary in relation to offences. We're at 13.19. Bates says, a person may not take any action which will have or is likely to have a significant impact on a listed threatened species. Substantial penalty units apply. 5,000 penalty units, which is currently $550,000. Now that's a maximum, and the concept of penalty units is that they replace dollar figures, which we used to see in legislation, and the reason for that is fairly obvious. Rather than having to make hundreds and if not thousands of amendments to acts by changing the value and increasing the fine, governments now simply need to alter the value attributed to a penalty unit. Now in relation... Yes, Laurie?
How would you calculate the, what is it, $1 per unit? Or
yes, $110 per unit, I think is the figure. That's certainly the figure at state level.
Yeah, John, is that that value, is that attributed to all, like in Queensland, is all legislation penalty points the same value?
Yes. Look, it's $110 per penalty unit, I believe both at the state and federal level. I have a sneaking suspicion that it's about to go up, or it may have just gone up, but it's been that for quite a while. Thanks, Paul. Thanks, Laurie. But of course, when you see that as a maximum, rarely do we even get close to that in reality. Bates goes on to talk about the Lamatina case from 2009, where the respondent was ordered to pay a pecuniary penalty of $220,000 for unlawful clearing native vegetation, and in that case there was likely to have a significant impact on an endangered cockatoo. To my mind, they're very significant penalties. All right, let's have a look at the state law, page 526. Just a brief comment in the introduction at 13.34. Every state, of course, has legislation that prohibits or controls the taking of most species of native Australian fauna and flora. Now, again, it comes back to that issue of separation of powers to a degree as well, in that here we have examples of an apparent duplication of laws both at the federal and state levels, and Philip Jeston spoke about that at some length in relation to the regime as it applies to environmental impact assessments. All right, so in Queensland at 13.50, it's an offence to take or keep certain protected animals or plants without authorisation. And over the page, there's a reference there to Booth and Yardley, where the respondent was ordered to dismantle an electric grid system constructed for the purpose of electrifying flying foxes. So that was regarded as an unauthorised interference with natural resources of protected areas and wildlife. In Central Queensland Society Against Central Queensland Cement, it was argued that blowing up a known overwintering site for protected ghost bats amounted to unlawful taking. Justice Thomas said it was not enough that destruction of nesting sites would probably damage descendants, but by contrast, Chief Justice de Jersey as he was then, held that since no bats had currently been living in the cave, destruction at that time could not injure, destroy or damage any bat. So have a look at that case in terms of the way in which the judges interpret these issues. Exemptions, page 540.
So, John, can I just ask a question about that as well?
Yes. Mm-hmm.
I noticed I'm not sure if it was that case or one of the other ones, they mentioned that like there's no disruption to the population if they're not there at the time.
Yes.
And this probably seems a bit simplified, but I'm pretty sure if someone dismantled my home while I was away and come back, I'm pretty sure there'd be some sort of disruption regardless of whether I was there or not. I mean, isn't that sort of common sense to some degree, or I don't know?
Look, I understand, and one might argue that different rules apply in relation to wildlife as opposed to human habitation, and that probably is the case. I suspect that you'd be a powerful advocate, Paul.
I could only try.
And thank you for that comment. All right, if we could go through to exemptions on page 540, there's an exemption available in relation to Aboriginal customs. And then over on page 543, threatened species, there's reference there to Victorian legislation, which was described as the first comprehensive piece of legislation in Australia. Now, 13.78, the Act provides for a list to be drawn up of species and communities of wildlife which are threatened, and another of potentially threatening processes. So it's not just the species that are threatened, but also there's a list drawn up of threatening processes. At 13.79, a flora and fauna guarantee strategy is to be prepared pursuant to the Act, and action statements drawn for listed species of flora and fauna and these potentially threatening processes that I talked about. Now, on page 546, we have commentary in relation to the other states, where Bates says that legislation elsewhere is of similar nature to that contained in the Commonwealth and Victorian legislation, singling out endangered and threatened species, populations and ecological communities of wildlife for selective treatment. Just over the page at 548, there's reference there to the case of Plath and Rawson, 2009. In that case, there was unlawful clearing of land. It resulted in a high degree of environmental harm, and an aggregate fine of $135,000 was imposed, and the defendant was required to pay, and I find this extraordinary, prosecutors' costs of $300,000. That's in New South Wales. It would be very rare, I should think, that would ever occur, certainly to that level in Queensland. It may have been that the matter must have been contested. It must have gone to trial to have costs anywhere near that figure. So it's not just necessarily the fine that's the impediment, but from a regulator's perspective in pursuing these matters, the threat of costs might be one of their biggest tools available in pursuing a matter. At 13.86, the court may order the defendant engage and in pay for qualified professionals to assess the damage that has been caused. And at 13.87, there are no statutory duties either to reveal information that discloses that a species is in fact threatened or identify such species, or in fact to trigger the process of listing. Now, a key point at 3.91, which deals with the listing of threatened species, populations, etc. So failure to list key threatening processes may be seen as significant omission. Many of the processes that threaten biodiversity are undeniably of human origin, yet to list a human process such as logging or development or removal of native vegetation as a threatening process and thereby trigger the obligation to prepare a threat abatement plan is often politically unpalatable. So we have there the difference between perhaps the environmental and the economics and the politics comes into play. Over at 3.92, one of the real problems with declarations of critical habitat is the fact that the decision to list critical habitat is often made by a minister, not by an independent scientific committee. Therefore, political consequences will inevitably weigh heavily on the decision-making process. Now, we're getting very close to the end, but I do want to stress 13.96, where Bates makes this comment. This chapter is mainly about managing native biodiversity and protecting it from unlawful interferences. This objective, however, cannot effectively be met unless biodiversity is also a fundamentally important consideration in land use planning and development control. Unless protection of biodiversity is linked with planning and development, then regulatory authorities responsible for biodiversity management and protection are fighting a losing battle. We talked in terms of where matters may be taken into consideration by regulatory authorities as opposed to when they must take those matters into consideration. And we've also talked about the weight that can be given to these factors by environmental authorities. So if the legislation, for example, provides that the authorities may consider something, then obviously they may consider it and discount it completely. Or if they must consider it but weigh it up against other factors, in essence the same problem can occur, that they say, well, we are required, we must take it into consideration, weigh it up against other factors, we have considered it and we attributed very little or zero weight, which means that in essence it's not taken into account at all. All right, now just at the end of the chapter, page 558, Bates says, where threatened species are concerned, then of course a precautionary approach to granting development consent would be justified. Such a process may lead to, if not the outright refusal of a development application, at least the revision of conditions of consent, including requirements for adaptive management and offsets, provision of a habitat management plan, or insistence on providing buffers. More detailed commentary in relation to precautionary approaches were provided in Chapter 7. Strategic planning was discussed in Chapter 8. Development assessment, IDAS, in Chapter 9 and 10. And the standards for considering relevant matters in decision-making later in Chapter 20. All right, well, I promised you an easy night tonight, so that's all I propose to discuss with you now. For those students in Laws 11046, I've posted some further examination tips. For the exam, you have the distinct advantage of it being open book. You can't take in something which will allow you to access the internet, but you are, of course, going to be well aware of the format of the exam by looking at past exams, and you'll see that essentially it's a requirement that you answer 5 of 7 questions. They're all going to be very general questions, essay format. So if you're able to describe a particular topic well in an essay format, then there's no reason why you can't do well in the exam. In the examination guide, which I've just posted, there's some further information about the topics that you might want to consider. Most of them, I guess, will be fairly obvious. In addition to the ones that I've already talked about, we will want you to consider such things as enforcement issues. I've stressed that a bit tonight. How do regulatory authorities go about enforcing environmental laws? What do they do? What are the impediments? Now, on the other side of it, there are the issues associated with community litigants wanting to enforce environmental laws. How do they go about doing that? And think back to what Roger Curry said and the commentaries associated with it. And while it's not a prescribed matter, there is the Community Litigants Handbook, which might be very useful in that regard as well. All right. Otherwise, are there any questions or comments? Yes, Paul, you've got a question?
Yeah, John, I was just wondering with assignment 2 regarding the CSG and that, in the legislation, from what I've found, it doesn't explicitly outlaw the use of evaporation ponds. Is that correct? I'm just wondering, like they've got a few examples, like you've got in your application, you've got to submit a best practice environmental management and show no feasible alternative. So I'm guessing if you can provide that, then they're going to say that, well, basically you have to do that to get approval.
Yeah, you can understand. Yeah, I'm always reluctant to give any specific advice in relation to assessment pieces, but I think you're on the right track.
I understand that.
But
Okay,
I think what you've done would be a good example. So thank you, Paul.
Yep. Okay, cheers.
Right. So any questions or comments? I trust that you're in. Yes, Laurie.
Is it the last Zoom? Is it?
What was that? Sorry.
Is this the final Zoom?
No, it's not. Next week, next Tuesday, the 13th of May, we'll be covering topics, chapters 15, 17 and 18. And then after that, on the 20th of May, this is for laws 11046, there'll be just a general exam discussion, open forum for anyone to ask any questions. So next week for this subject will be the last formal matter. Now, I haven't covered chapters 19 and 20 officially, but I think they're well worth a look at as well. And I'm sorry there's such a lot of material to cover. Thanks, Laurie. Any other questions or comments?
Actually, oh, sorry.
Yes, Paul.
John, just one other about costs in Queensland. We mentioned just briefly before. You said that it doesn't occur, the high costs in Queensland generally. Is that because up until recently, anyone who challenged like a development or an approval or something like that were more or less protected from costs?
Yes.
Only recently changed that legislation to basically, if you want to challenge it, it's up to you to pay the costs.
Yes, and you'll recall, of course, Roger Curry's comments in relation to costs and his experience, where the costs really ought to have been astronomical, but arrangements had been made there to get round that. But often courts won't award costs in circumstances where a community litigant, if pursuing a matter genuinely and appropriately, even though they might lose, will not suffer costs orders. Now, that's not always the case by any means. And the general rule is that if you pursue litigation and you lose, then you will be awarded costs against you on what we call a party-and-party basis, which is basically the amount that's assessed as appropriate. So,
okay.
Yeah, and the same thing can apply in prosecutions as well, and the prosecutors can claim their costs in many environmental prosecution matters, but it doesn't happen generally in criminal law matters. We just, apart from some limited Commonwealth matters, generally speaking, costs aren't awarded against a defendant who chooses to defend a criminal law proceeding. That's in Queensland.
Okay. So when you're talking about environmental like challenges and things like that, is it sort of deemed because it's in the interest of the community? They tend to not even if you lose, say for Roger's example, because it was sort of in the interest of the community, it's not deemed to be a cost that should be worn by the objectors or whatever.
That's right. Yes, it's certainly a factor to be considered by the courts, and on many occasions the courts have elected not to have exercised their discretion not to award costs. So costs is a discretionary issue for the court, depending on all the circumstances. Thanks, Paul.
Okay, thanks, John.
All right. No further questions or comments. I'll stop recording now, so thank you.